Hello friends, in the series on the income tax cases, today we will discuss an issue which was before the Honorable Supreme Court, and the issue was that if an assessee is a tax resident of Singapore and the assessee has developed a business application which is used by the Indian customers by paying a fixed subscription fees, and there is no transfer of any copyright in that application to the Indian customers, and the use of that application is only restricted to the analytical attributes of that application. So whether this subscription fees received by a Singapore resident company from the sale of that business application through subscription fees is termed as royalty as per section 9 subsection 1 clause 6 and as per article 12 subarticle 4 clause B of the double taxation avoidance agreement between India and Singapore. This issue has been decided by the Honorable Court in the case of Commissioner of Income Tax versus Salesforce.com Singapore Pte Limited, and this case is reported in 479 ITR at page number 219, and the date of the judgment is 1st August 2025. The present case relates to the assessment year 14-15. The facts of the case is this, that in the present case the assessee is a tax resident of Singapore and the assessee has developed a business application, and this business application is being used by the Indian customers for the various services like customer relationship management related services by paying a fixed amount of subscription to the assessee, which was a Singapore tax resident, and in regard to that subscription fees, the assessee has to put its data into that application, and then the application was processing that data, and by using the analytical attributes of that application, the assessee was getting the desired results. So this was the whole modus operandi. When the assessing officer go through this whole modus operandi, the assessing officer made a view and showcased the assessee that why this subscription fees received by the assessee should not be treated as royalty as per section 9 subsection 1 clause 6. The assessee submitted its explanation by saying that there is no transfer of the copyright in the business application and hence it should not be treated as royalty. But the assessing officer included that amount into the income of the assessee as per section 9 subsection 1 clause 6. When the matter was before the tribunal was of the view that in the present case the assessee was receiving the subscription fees from the customers in India, and when this subscription fees was received from the various customers in India, there was undoubted fact that there was no transfer in the copyright in that application which has been transferred to the Indian customers. The customers which were related to the India were merely accorded the access to the application to the extent that they were putting the data into that application, and then the benefit of the analytical attributes of that application were made available to the assessee. The tribunal was of the view that by reading through the article 12 subarticle 4 clause B of the double taxation avoidance agreement and by analyzing the section 9 subsection 1 clause 6 of the Indian Income Tax Act 1961, the present amount which was in the form of subscription fees from the sale of that business application cannot be termed as royalty, and hence deleted the addition made by the learned assessing officer. The same view was upheld by the High Court, and when the revenue travelled to the Supreme Court also dismissed the special leave petition of the revenue. Friends, this case is very important because whenever these type of incomes are the subject matter of the scrutiny proceedings, the assessing officers very casually make a view that these are either in the definition of royalty or they are in the definition of fees for technical services. So this case is very important as far as treating those amount as a royalty by the revenue is concerned. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax versus Salesforce.com Singapore Pte Limited, and this case is reported in 479 ITR at page number 219, and the matter has been decided by Honorable Apex Court on 1st August 2025. Thank you, friends.